And greetings. Welcome. We're about to start. Let's try that again. Greetings. Oh, shit. All right. Greetings and welcome. All right. I guess we're out there. We're broadcasting on YouTube and we are live. So, welcome to all. We're going to do a brief review of Black's Law Dictionary, and we're going to be focusing on just a few words. If everyone's here, please hit the thumbs up to make sure that the algorithm knows that we are actually out here broadcasting something useful. And let's get some people in here so we can share this information. I find that there's a lot of common words that have been used as of late, trying to express people's desire to exercise their common law rights and such. And with confusion around some basic words that have essentially been unchanged for hundreds of years, it behooves us to learn the definitions of these words as they are used in a lawful context, and also the etymology of the words so we can have a better understanding of where they came from, where they apply, and why they have been left unchanged for so long. So, before we do get started, I just want to remind everyone that this is not to be considered any kind of legal lawful advice for anything personal, professional, or otherwise, just as an educational entertainment purposes only. Don't do this at home. With that said, if everyone's here, please pipe in the chat so I know we're all here, and let's get started on a brief Black's Law Dictionary review. So, with the first word we want to go over is allegation. Allegation comes from the 15th century. It's a noun. The first definition is it's an act of declaring something to be true. Second definition is something declared or asserted as a matter of fact, especially in a legal pleading. A party's formal statement, formal, see, we're using words like legal and formal, because legal is contemplating the form of law. And when we're trying to assert facts of law, then that's actually contemplating the substance. So the legal is concerned with form, as we see it restated here. A legal pleading, a party's formal statement of a factual matter as being true or provable without its having yet been proved. So it's a statement as if it's true, but it has not yet been proved true. So we have also here a defensive allegation. There's very many kinds of allegations we could go over here, but just to go over some of these, we'll find some of the little extra divergence they have here that give us a little bit more detail. So a defendant's response in an ecclesial action. Ecclesiastial, gosh. A defendant's pleading of the facts relied upon that required the plaintiff's response under oath. So the proceedings in the ecclesiastial courts are therefore regulated according to the practice of the civil and canon law. So I'm not going to get into too many of these, but let's look at some of these here. Disjunctive allegation. 1814, a statement and a pleading or indictment that expresses something in the alternative. Usually with the conjunction or. A charge that the defendant murdered or caused to be murdered. is a disjunctive allegation. Now we see this used quite a bit. Federal civil procedure. So if anything is like a Section 1983 that's being done, then that might actually be applicable. So that's in civil procedure. Material allegation. 18th century. In a pleading, an assertion that is essential to the claim, charge, or defense. A material allegation in the battery case is harmful or offensive contact with a person. There's primary allegation, allegation of faculties. Let's see if there's anything else here that's it. Those are some pretty good ones in here. We could go into more detail, but to keep things more in context, let's go on to the second word. Give me one moment here, and the second word is claim. Claim comes from the 13th century. It's the aggregate of operative facts giving rise to a right enforceable by a court. The plaintiff's short, plain statement about the crash established the claim. Also termed claim for relief, 1808. Definition 2 is the assertion of an existing right, any right to payment or to an equitable remedy, even if contingent or provisional. So this is our definition 2. Here's an example: the spouse's claim to half of the lottery winnings. So a claim on definition 2 would be an existing right, asserting an existing right, and payment or equitable remedy. So let's continue. Number 3, a demand for money, property, or a legal remedy to which one asserts a right, especially the part of a complaint in a civil action specifying what relief the plaintiff asks for. And we're back to the federal civil procedure rules. So we have very many kinds of claims depending on the kind of case it is and the subject matter. Donation claim, honest claim, a claim made by someone who believes, however unreasonably, that he or she has a right to something or that there is a chance that such a right exists. That's an interesting one there. A liquidated claim, a claim for an amount previously agreed on by the parties, or that could be precisely determined by operation of law by the terms of the parties' agreement. 2. A claim that has been determined in a judicial proceeding, also termed liquidated demand. So it's been determined in a judicial proceeding, the claim. So I guess a liquidated claim would be ready to be taken to action, how it will be remedied. Let's see what else we have here. Matured claim, a claim based on a debt that is due for payment. All right. We go down stale claim, a claim that is barred by the statute of limitations or the defense of laches, also termed stale demand. So I guess it goes stale after a statute of limitations. That goes to 18th century. Then we get the unliquidated claim, the negative of this liquidate. Here we have a claim in which the amount owed has not been determined. And then we have, number 4. An interest or remedy recognized at law, the means by which a person can obtain a privilege, possession, or enjoyment of a right or thing. Cause of action. Claim against the employer for wrongful termination. So this is definition 4. Interesting. How this gets slipped in there. Did we miss something here? Okay, I'm just double checking here. I didn't see a 3. To an equitably remedy. Oh, there it is. 3 buried in there. There it is. The demand for property. Okay. Just checking here. Again, this is a terribly scanned document. Bear with me on this. I appreciate everyone sticking around. All right, Matrix Transparency is here. Welcome and greetings. Greetings to everyone here. Okay, so back to where we were here. Number 4. We're back to definition 4 of claim. An interest or remedy recognized at law. The means by which a person can obtain a privilege, possession, or enjoyment of a right or thing. A cause of action. 1. So this is interesting here. A claim is the cause of action. A claim against the employer for wrongful termination. Ancillary claim, 1906, a claim that is collateral to, dependent on, or auxiliary to another claim, such as a state law claim that is sufficiently related to a federal claim to permit federal jurisdiction over it. The concept of an ancillary federal jurisdiction is now contained in the Supplemental Jurisdiction Statute 28 U.S.C. Okay, we get it. We have a colorable claim. Let's see what we got here. Passing out privilege like candies instead of natural rights for remedy. Well, these are in civil actions, though. This was taken, something that couldn't be remedied in the private, and it was taken to the courts. And this is how they have to dole it out. These are ways disputes have been settled without violence since, 13th century so far. So I guess it behooves us to learn some of these terms because I guess the alternative might not be as well. A colorable claim is a claim that is legitimate and that may reasonably be asserted given the facts presented and the current law, or a reasonable and logical extension or modification of the current law. Wow, now that's kind of a colorable claim. Legitimate it may reasonably be asserted given the facts presented and the current law, or reasonable and logical extension or modification of the current law. Let's continue on this colorable claim. Number 2, a claim in which the debtor and property holder are, as a matter of law, not adverse. Colorable claim. Now that's interesting. A claim in which the debtor and property holder are, as a matter of law, not adverse. An example of a colorable claim is one made by a person holding property as an agent or bailee of the bankrupt. Okay. There we go. Then we have contingent claim, a claim that has not yet accrued and is dependent on some future event that may never happen. So a contingent claim. This is an interesting one here, and I think this might even apply in one of the other live streams we did covering trusts. Counterclaim, cross-claim. Frivolous claim, a claim that has no legal basis or merit, especially one brought for an unreasonable purpose, such as harassment. That's from the Federal Rules of Civil Procedure. Supplemental claim, a claim for further relief based on events occurring after the original claim was made. Supplemental. So this is, I guess, after a case perhaps has commenced, you could add supplemental claim. Or maybe it's a bankruptcy in 1842, a right to payment or to an equitable remedy for breach of performance if the breach gives rise to a right of payment. It does not matter whether the right has been reduced to judgment or whether it is liquidated or unliquidated, fixed or contingent, matured or unmatured, disputed or undisputed, secured or unsecured. Wow. The right to payment or to an equitable remedy for breach of performance. Now this is quite interesting here. if the breach gives rise to payment. And that's from 1842 in bankruptcies. For breach of performance. Interesting. Okay, so let's continue on this. Creditor's claim, a claim that a creditor has against a debtor. Involuntary gap claim, claim that accrues in the ordinary course of business after an involuntary bankruptcy petition has been filed but before the order. Okay, so we're getting to the bankruptcy law here, which I don't want to get lost in the weeds with that. Priority claim, an unsecured claim that under bankruptcy law must be paid before other unsecured claims. Secured claim, a claim held by a creditor who has a lien or a right of set-off against the debtor's property. Unsecured claim. 1. A claim by a creditor who does not have a lien or a right of set-off against the debtor's property. 2. A claim by a creditor to the extent that its lien on or right of set-off against the debtor's property is worth less than the amount of the debt. Ah, that's another nice one there too. Then we have claim and delivery, claimant. So we've finished up here with claim. So if you're with us this far and you haven't hit the like, please hit the like so we can get more people in the room here as we move on to the next one, which is a drum roll here. And it's fact, in fact. From the 15th century. Definition 1 of fact. Something that actually exists. An aspect of reality. It is a fact that all people are mortal. Hey, the word wizard is here. You're at the venue that matches your name. Facts include not just tangible things, actual occurrences and relationships, not just those, but also facts include states of mind, such as intentions and opinions. Let's read this again. Facts include not just tangible things, actual occurrences and relationships, those are all facts, but also includes states of mind, such as intentions and opinions. 2, an actual, well, it's a fact that you had an opinion, I think is what it comes down to. An actual or alleged event or circumstance. Look at this, actual or alleged. And we already went over allegation. Event or circumstance. Now, that means it hasn't been substantiated with fact, which we're going over now, as distinguished from its legal effect, consequence, or interpretation. So an actual or alleged event or circumstance, as distinguished from its legal effect, consequence, or interpretation. As distinguished. Key word here. So a fact is the actual or alleged event or circumstance as distinguished from its legal effect, consequence, or interpretation. Legal interpretation. Thank you, word wizard. Exactly. So pretty good stuff here so far that is fundamental. They should have taught this in every elementary school. And now I guess we could see why it's so powerful when we look at something from the 15th century that is so meaningful to us for today. So let's read definition 2 again for fact. An actual or alleged event or circumstance, as distinguished from its legal effect, consequence, or interpretation. So an example here is the jury made a finding of fact. 3, an evil deed, a crime, an accessory after the fact. So a fact is any act or condition of things assumed for the moment as happening or existing for the moment. So this is very interesting to consider here, and this is from the textbook of Law and Evidence. And if everyone's interested in things like this, like evidence, I do have a lot more documentation on evidence of some very fundamental and lawful, I guess, textbook type of stuff with this that's probably becoming more and more of a lost practice and a lost art. And I'd be happy to share some of that too if there is that much interest. Let's continue here a bit. So a fact is any act or condition of things assumed for the moment as happening or existing. So for the moment, operative. So we have ablative facts. Adjudicative fact. And they give us nice pronunciation. Thanks. Adjudicative or cative. Adjudicative. I like adjudicative more. 1959. A controlling or operating fact rather than a background fact. A fact that concerns the parties to a judicial or administrative proceeding. Nice. Judicial or administrative proceeding. And that helps the court or agency determine how the law applies to those parties. For example, adjudicative facts include those that the jury weighs. Oh, nice. So, yes, I guess you said it, not me. Matrix transparency. They didn't teach us this stuff in school because they didn't want us knowing it. But it's been around, as we see. These are some pretty old words, 15th century. It's a long time in hiding in plain view, I like to say. All right, with that, let's continue. We have alienative facts. Let's see, alienative or alienative. A fact that divests a person of a right by transferring it to another. So you alienate. Wow. Alienate a right. It's an alienative fact. Fact that divests a person of a right by transferring it to another. Wow. Now that's an important word right there. Alienative fact. A fact, something so powerful, can divest it says a person here too, of a right by transferring it to another. Well, that's quite interesting. Ancient fact. A fact about a person, thing, or event that existed or occurred a very long time ago, and about which no living person has first-hand knowledge. Also termed fact and pais. So this is quite interesting here. A fact about a person, thing, or event that existed or occurred very long time ago, an ancient fact, and about which no living person has first-hand knowledge. Collateral fact. A fact not directly connected to the issue in dispute, especially because it involves a different transaction from the one at issue. Nice. And we have collative facts, the investigative fact. All right, let's stick with these, the ones I have pronunciations for tonight. denotative or denotative or denotative fact. A fact relevant to the use of a non-legal term in a legal rule. Hey, I like that one. It's a fact relevant to the use of a non-legal term in a legal rule. So an interesting thing would be to see if we could come up with a list of denotative facts or denotative facts about a particular subject matter. I'd be interested in seeing examples of some of these. A fact relevant to the use of a non-legal term in a legal rule. We have a destitutive fact. Dispositive fact. 1946. A fact that confers rights or causes the loss of rights. This is worse than the alienative fact, which is just transfer of rights. So this is a pretty dispositive. All right, so we have this guy with the backwards name here, Mike. Well, okay. Hearsay of scripture, use of denotative verses that correlate to the legislative legal rules. Okay, let's move along here. Dispositive fact is a fact that confers rights or causes the loss of rights. A dispositive fact may be either an investitive or a divestitive fact, also termed vestitive fact. 2. A fact that is decisive of a legal matter, evidence that definitely resolves a legal issue or controversy. See disposition. Very interesting. Dispositive, disposition. Much like, alienative, but not quite. There are some distinctions here, and that's why we have different words. What a concept. So, again, there's a certain level of precision that's to be applied in the right context. And by diving deeply into these words, we learn the context where they apply the most and the more forcefully and give us the best impact for the language we use. Because this is the way we execute our transactions, is by words. So this is where the rubber meets the road, what we're doing here, because this is a law dictionary, and by understanding the law, we can apply it in the forms of different legal matters. So the legal depends on the substance of law, and by understanding the substance of law, there should be no trickery when it comes to any kind of application of legal, any kind of shenanigans or administrative ministerial acts that are not lawful. So by exercising and knowing these facts will help us distinguish when people are being truthful and honorable or trying to get one over, which it seems that it's quite prevalent today with a lot of the institutions. All right, I've digressed enough. Let's continue on here. We have elemental fact. See ultimate fact. I missed. We get the divestive, right? Divestitive, right? A fact that causes the loss of rights, or an act or event modifying or extinguishing a legal relation. So we did miss that. All right. So again, after the divestitive. 1973, a fact that causes the loss of rights. An act or event modifying or extinguishing a legal relation, extinguishing it. A divestitive fact, also termed extinctive fact, destitutive fact, elemental fact. See ultimate fact. Evaluative fact, 1986. A fact used to assess an action. as being reasonable or negligent. Beautiful. All right, I want everyone to take note of this one. An evaluative fact, to evaluate, to test the value, the valor. How valuable is the act being used, the action? So an evaluative fact is a fact used to assess, to grade, to give an objective measure to the value of an action as being on the scale of reasonable to negligent. The evaluative fact gives us a number on a scale. How much percentage negligence? So do you see how these all come together like this, where the law meets a way? How can we bridge between what's lawful and what's going to be objective and enumerated and measured in the legal context? And we use things like an evaluative fact to assess an action as being reasonable or negligent, and to what degree. Beautiful. Evidentiary fact. Evidentiary, 1855. A fact that is necessary for or leads to the determination of an ultimate fact. Can't wait to get to this one. Also termed predicate fact. 2. A fact that furnishes evidence of the existence of some other fact. Also termed evidential fact. See fact and evidence. Exonerative fact, exonerative or exonerative, exonerative, sounds good to me. 1980, wow. A divestitive fact that extinguishes a duty. Oh, this sounds pretty onerous here. Extinctive fact. See, okay, we saw that one. Fabricated fact. See, fabricated evidence under evidence. And here we go. Fact and evidence, 18th century. A fact that a tribunal considers in reaching a conclusion. A fact that has been admitted into evidence in a trial or hearing. Also written fact and evidence. Also termed evidentiary fact. Okay, so this is a fact that a tribunal considers in reaching a conclusion. So a fact that has been admitted into evidence, which we'll be getting to also, but in a trial or hearing. So it's a specific kind of fact, one that a tribunal considers. Also written fact and evidence. So a fact and evidence, or briefly, evidence. See, we're getting a little bit closer here to the final word of the night. Signifies any facts considered by the tribunal as data to persuade them to reach a reasoned belief upon a probandum. This process of thought by which the tribunal reasons from fact to probandum is termed inference. What the heck is probandum? We'll have to look that one up right now. So, probandum. Let's take a little digression here as the slow scrolling search here works on this terribly scanned document. Wow, I didn't realize there's a heading in here too. Wow. Most of the pages don't even have numbers on them, so it makes it really hard to scroll through. Where are the L's? I wasn't expecting this word for tonight, but we can't leave any word behind. Getting there, jeez. And it's at the end of the piece. Oh shit. All right, it's getting there. Go a little slower here as we don't pass it. I'll edit this part out of the video. Come on. All right. We're getting close. Very close. Very warm. Come on. I don't want to jump too far because then it's going to pause and I know we're close enough. Geez, there's a lot of P. All right. Is it probatum? Something conclusively established or proved. Was that the word? Probatum? Well, if it's not, I'm going to write down this page number so we can get to it quickly if we have to. All right. Let's go back to where we were. It won't take that long. Probandum. All right, no problem. We'll get right back there. Probandum. Oh, come on. Probandum. A fact to be proved. So there it is. Probandum. A fact to be proved. So it's not a fact yet. All right. Thanks for bearing with me on that digression. Let's get back to facts. So we left off right here. So a fact in evidence, or briefly evidence, signifies any fact considered by the tribunal as data to persuade them to reach a reasoned belief upon a probandum, which is one that hasn't been proven yet. This process of thought by which the tribunal reasons from fact to probandum is termed inference. All right. So let's go on. Fact and issue. Usually plural, facts and issue, I guess. 17th century, historical. A fact that one party alleges and that the other controverts to. A fact to be determined by a fact finder, probandum. We just went over. We're glad we went over that word. Also written fact and issue. So it's to be determined. Fact and issue, to be determined. A fact and issue is a fact as to the correctness of which the tribunal, under the law of the case, must be persuaded. The term probandum, thing to be proved, will here be used as the convenient single word. Yeah, we're getting about that. If it gets to this, then you can just imagine that the parties really had a dispute to actually bring it to this extent of splitting hairs. If people could be more honorable, we probably wouldn't need this. But this is 1935 and 17th century, so fact and issue's been around for quite a while. Fact and evidence, 18th century. But on that one, we are back into the ancient fact, the fact material to risk insurance, a fact that may increase the risk. Okay, so now this is an interesting one here because this applies to insurance. A fact that may increase the risk and that, if disclosed, might induce the insurer to either decline to insure or to require a higher premium. Fact material to risk. Then we have a foundational fact, immaterial fact, a fact that is not relevant to a matter in issue. Impositive fact, an investitive fact that imposes duties. That's an interesting one. A fact that imposes duties. Inferential. So now if we consider it that imposes duties, and that's quite interesting that they investitive fact. An impositive fact is an investitive fact that imposes duties. To go back to investitive fact, yeah, divestitive. Do we go over that one yet? I guess we haven't. All right, so we'll be to that one soon. Let's just skip ahead to it. Investitive. I don't see it here. Oh, there it is. Investitive fact, a fact that confers rights. Okay, so we went over something in there I recall coming across here, but 1939, this particular word, investitive fact, is particular from 1939, a fact that confers rights. Yes, sir. Confer, conference. So now we see here where this ties in to the impositive fact. It's an investitive fact, one that confers rights and imposes duties. Beautiful. And so this is another one to consider, an impositive fact. You know, an oath could be considered an impositive fact. So let's see here. Inferential fact, 1958. A fact established by conclusions drawn from other evidence rather than from direct testimony or evidence. A fact derived logically from other facts. So this is the inferential fact, 1858. This is relating back to the this other one we were looking at here, facts in issue 2. It's an inference. So the inferential fact is a fact established by conclusions drawn from other evidence rather than from direct testimony or evidence, a fact derived logically from other facts. Then we already went over investitive fact and judicial fact, 1862. So judicial notice fact, okay. So judicially noticed fact, a fact that is not established by admissible evidence, but may be accepted by the court because the fact is generally known within the trial court's territorial jurisdiction, or because its validity can be determined from sources whose accuracy cannot be reasonably questioned. Well, what kind of source is that whose accuracy cannot be reasonably questioned? I can't think of very many. Also termed judicial fact. See judicial notice. Then we have jurisdictional fact, usually plural, 1837. A fact that must exist for a court to properly exercise its jurisdiction over a case, party, or thing. See jurisdictional fact, doctrine. Then we have legal fact. Legal fact, 18th century. A fact that triggers a particular legal consequence. A fact that triggers. So we have facts that can confer, that can alienate, transfer, lots of things that facts can do. Are you seeing how powerful the word fact is? It may be a noun, but it causes action. Cause of action. A fact that triggers a particular legal consequence. Legislative fact, 1828. A fact that explains a particular law's rationality, and that helps a court or agency determine the law's content and application. Now, think of this, the legislative fact, if you look at any law, especially things like, from state laws when they were first formed, you'll find there's a particular form to those laws where there will be, legislative facts in there explaining their law's rationality. And they're used to help the courts decide because the courts will refer to those particular explanations of rationality to determine the cases. Let's see. Legislative facts are not ordinarily specific to the parties in a proceeding. Adjudicative fact. So let's see what the footnote is here. Legislative fact includes matters needed to construe statutes or regulations and factual assumptions a court makes when called upon to legislate. So examples of the latter might include the fact that spouses will communicate less if they are not granted a privilege covering their confidences. Wow. Or that marital harmony will be strained if spouses can be compelled to testify against each other. Facts which might be useful in helping a court decide whether to create or continue a common law marital privilege. Wow. Obviously, legislative facts of this nature do not and cannot meet the indisputability criterion of the rule, nor are they required to. So this gets to the federal rules of evidence again. So, explaining the law's rationality, but legislative facts are not ordinarily specific. This is interesting example they have here. Yeah, we need a little diversion from that. Law and fact are distinguishable. Fact is very frequently used in opposition or contrast to law. True, very true. And here's one aspect where they will try to defend it through legislative rationality written into the laws. All right, let's continue. Great feedback from everyone out there in the chat. I hope enough of you can stick along for this, but we're going to trudge it to the end. We're almost there. Marital fact, material fact. 1848, a fact that is significant or essential to the issue or matter at hand. Essential. Material facts are essential or significant. So it could be either or. Minor fact, a subordinate fact or circumstance. Oh, we're getting to that word wizard. Don't you worry. Operative fact, 1857. 1. A fact that affects an existing legal relation, especially a legal claim. That's your operative fact. One that affects an existing legal relation, especially a legal claim. Operative, operate, another verb spawned by our noun of fact. When applying the hearsay rule, this term distinguishes between out-of-court statements that are operative facts. An example, a party saying, I agree to reimburse you, in a case for breach of oral contract. And hearsay, out-of-court statements that only relate to operative facts. An example, Joel told me Mike said he would reimburse me. Wow. So, yeah, this is interesting here when you look at the operative fact. It's a fact that affects an existing legal relationship, right? Now, when applying the hearsay rule to this term distinguishes between out-of-court statements that are operative facts. So in an oral contract, right? That's an operative fact. Wow. And hearsay, out-of-court statements that only relate to operative facts. So Joel told me Mike said, oh gosh. Hearsay, that's the hearsay rule being applied to operative facts. So great stuff here. Definition 2, a fact that constitutes the transaction or event on which a claim or defense is based. So there it is. The operative fact is also a fact that constitutes the transaction. Constitutes, another verb, great. Physical fact, 1857, a fact having a physical existence, such as a fingerprint left at a crime scene. Predicate fact, 1899, a fact from which a presumption or inference arises, cases, criminal law. A fact necessary to the operation of an evidentiary rule. For example, there must actually be a conspiracy for the co-conspirator exception to the hearsay rule to apply. Also termed foundational fact, evidentiary fact. Presumed fact, a fact whose existence can be justifiably inferred, back to our conference of logically inferred, from facts established by evidence. So presumed facts, a fact whose existence can be justifiably inferred from facts established by evidence. So those are certain kind of facts that can you can justifiably infer this presumed fact. Then we have primary facts from the 18th century, a fact that can be established by direct testimony and from which inferences are made, leading to ultimate facts. We're getting there. Principal fact, see fact and issue. See ultimate fact, we will. Private fact, 16th century. Okay, a fact that has not been made public. Whether a fact is private often arises in invasion of privacy claims. It's also the public fact. Probative fact, 1858, a fact and evidence used to prove an ultimate fact, such as skid marks used to show speed as a predicate to a finding of negligence. Boy, we're creeping up on this ultimate fact, but I think the suspense is good. Psychological fact. Wow. A fact that is related, remember we said that could be a mental state of fact, such as motive or knowledge. Knowledge is a psychological fact. Public facts, 1955. For the purpose of an invasion of privacy claim, a fact that is in a public record or in the public domain. Nice. Wow, cases in tort. Relative fact, a fact incidental to another fact, a minor fact. Simulated fact, 1943, a fabricated fact intended to mislead. A lie. Lie. Simulated fact is a fabricated fact intended to mislead. It is a lie. So we just learned a new definition for lie, a simulated fact intended to mislead. All right, translative or translative fact. A fact by means of which a right is transferred from one person to another. A fact that fulfills the double function of terminating one person's right to an object and of originating another's right to it. Wow. Pretty good stuff. Yes, this stuff is fire. So I didn't even realize how deep this rabbit hole was going to be with these few words I chose for tonight, but they are quite deep. So transvestitive fact, a fact that is simultaneously, wow, investitive and divestitive. Transvestitive, oh Lord. When a person transfers the rights he has to another, the transfer divests him of the, let's see if we can get this word to show up better, the potestas, and invests the other with it. This is quite distinct from the creation or extinction of the potestas. A new descriptive term is wanted, and after the analogy of the other words, transvestitive has been coined for the purpose. Wow. All right, so there it is, transvestitive fact. And now we're on to the one we've all been waiting for. The ultimate fact comes from the 18th century. A fact essential to the claim or the defense, also termed elemental fact, principal fact. Beautiful. And of course, this ties us back to the last word we did, which was claim. The ultimate fact is a fact essential to the claim or the defense. Undisputed fact, also from the 18th century, is an uncontested or admitted fact. We saw vestitive fact, and we are done with fact. And we're on to the next word. Oh boy. And the next word is, can you guess what it's going to be? There it goes. Proof. Another noun from the 13th century. Definition 1. The establishment or refutation of an alleged fact by evidence. The persuasive effect of evidence in the mind of a fact finder. Wow. The establishment or refutation of an alleged fact by evidence. Right? We still haven't gotten to evidence. That's going to be our last word, but we've gone over allegation. We've gone over fact by evidence. But furthermore, proof is the persuasive effect of evidence in the mind of the fact finder. Affirmative proof, evidence establishing the fact in dispute by preponderance of the evidence. You know, this just tells me that we need to get to evidence first. I guess I had this in the wrong order. Let's jump over to evidence. We'll come right back to proof. All right. Evidence, 14th century. Something, including testimony, documents, and tangible objects, that tends to prove or disprove the existence of an alleged fact. Okay, so we've tied in a lot of stuff here. Evidence is something, which could be testimony, documents, tangible objects, that tends to prove, which we're getting to also, or disprove the existence of an alleged fact. So the bloody glove is the key piece of evidence for the prosecution. 2. See fact and evidence, which we did under fact. The collective mass of things, especially testimony and exhibits, presented before a tribunal in a given dispute. The evidence will show that the defendant breached the contract. The body of law regulating the admissibility of what is offered as proof into the record of a legal proceeding. Under the rules of evidence, the witness's statement is inadmissible hearsay that is not subject to any exception, also termed rules of evidence. So here we go. I love these little footnotes here. Evidence is any matter of fact which is furnished to a legal tribunal otherwise than by reasoning or a reference to what is noticed without proof as the basis of inference, the logical reasoning, in ascertaining some other matter of fact. Oh, so ascertaining some other matter of fact. Evidence, broadly defined, is the means from which an inference may logically be drawn as to the existence of a fact. So evidence is the means by which the inference may be logically drawn as to the existence of a fact. That which makes evident or plain. Now it starts to make some sense, right? Evidence is the demonstration of a fact. It signifies that which demonstrates, makes clear, or ascertains the truth of the very fact or point in issue, either on one side or on the other. In legal acceptation, the term evidence includes all the means by which any alleged matter of fact, the truth of which is submitted to an investigation, is established or disproved. Evidence has also been defined to mean any species of proof legally presented at the trial of an issue by the act of the parties and through the medium of witnesses, records, documents, concrete objects, and the like. Beautiful stuff. That's a great illustration, I guess, clarification of evidence. And I think is the best line out of this one here, I think, is where it just is the means from which it signifies that, well, that which demonstrates, makes clear, or ascertains the truth of the very fact or point in issue, whether on one side or on the other. So this is the way that you can ascertain whether something is true. It's looking to find the truth through a process, and the process of evidence, right? Making clear, making it evident, making the truth evident. And how best to do that after the fact? Well, that's when it gets into the rules of this, right? The truth of which is submitted to investigation, is established or disproved. So there it is. Let's continue. Adminicular evidence, rare, good. Corroborating or auxiliary evidence presented for the purpose of explaining or completing other evidence. Then we have admissible evidence, 18th century. Evidence that is relevant and is of such a character, an example, not unfairly prejudicial, based on hearsay, or privileged. Notice this, privileged. So admissible evidence is not privileged. Interesting there too. So it's evidence that is relevant and is of such a character, and the example given here is not unfairly prejudicial. This is a very important term here, not to be overlooked. Biased and unfairly prejudicial evidence being admitted is not, it should be forbidden. If it's based on hearsay, or privilege, meaning that you cannot go through the particular process of the submission to an investigation to determine the truth, right? Because it's privileged. You can't put it under an investigation. So it cannot be admissible evidence. Also termed competent, that the court should receive it, right? So evidence that is relevant and is of such a character, example given, not unfairly prejudicial, based on hearsay or privileged, that the court should receive it. Also termed competent evidence, proper evidence, legal evidence. We have topic evidence, best evidence, 17th century. But here, this one's better. See demonstrative evidence. We'll be there soon. Best evidence, 17th century. Evidence of the highest quality available. Best evidence. As measured by the nature of the case rather than the thing being offered as evidence. So again, back to the context. The terms usually apply to writings and recordings. If the original is available, it must be offered rather than a copy or oral rendition. Did you read this? The best evidence. This is the term from the 17th century. It's the evidence of the highest quality available. It's measured by the nature of the case rather than the thing being offered as evidence. So in other words, if it's something that has to do with a very high stakes asset, you would want to see the best evidence because of the nature of the case rather than if it's just something, some petty little disagreement in small claims. It wouldn't necessarily be as important to the nature of the case of things being of such a high quality of the best evidence, right? That's applied to writings and recordings. So if the original is available, it must be offered rather than a copy or oral rendition. So, thorough rules of evidence, also termed primary evidence, original evidence. See best evidence rule. All right, here we go. Beautiful. In some circumstances, best evidence may mean that evidence which is more specific and definite as opposed to that which is merely general and indefinite or descriptive. However, best evidence or primary evidence is variously defined as that particular means of proof which is indicated by the nature of the fact under investigation as the most natural and satisfactory, or as that kind of proof which under any possible circumstances offers the greatest certainty of the fact in question, or as evidence which carries on its face no indication that better remains behind. Wow. So this kind of brings us all together. Do you see how we have the recurring theme of these words? If you don't have the depth of understanding as we've gone over tonight of these words like fact and proof, then these it probably doesn't mean as much. But once you get the full definitions down of these words and what they really mean in context, it allows one to see where the complexity of this applies and where it doesn't. Okay, so once again, let's get down to the character evidence, 1949, another new one. Evidence regarding someone's general personality traits or propensities of a praiseworthy or blameworthy nature. Evidence of a person's moral standing in a community. Character evidence is usually, but not always, prohibited if offered to show that the person acted in conformity with that character. Circumstantial evidence, 18th century. Evidence based on inference. Remember that logical reasoning and not on personal knowledge or observation. Also termed indirect evidence, oblique evidence. And that's to be a contrast with direct evidence. Definition 2. All evidence that is not given by eyewitness testimony is circumstantial. Oh boy. Indirect evidence, called by the civilians oblique and more commonly known as circumstantial evidence, civilians, is that which is applied to the principal fact. Remember we went over principal fact ultimate fact, indirectly or through the medium of other facts. So indirect evidence, right, is that which is applied to the principal fact, indirectly or through the medium of other facts, by establishing certain circumstances or minor facts already prescribed as evidentiary, from which the principal fact is extracted and gathered, by a process of special inference. Special inference. That's a special process there. Some circumstantial evidence is very strong, as when you find a trout in the milk. So evidence of some collateral fact from which the existence or non-existence of some fact in question may be inferred as a probable consequence is termed circumstantial evidence. That's from the Laws of Evidence, 1928. Testimonial evidence readily defines itself by its name. It is any assertion by a human being offered to evidence the truth of the matter asserted. Testimonial evidence readily defines itself by its name. It is testimonial evidence, any assertion by a human being offered to evidence the truth of the matter asserted. Circumstantial evidence is any and all other evidence. So there's only two kinds of evidence, I guess. There's testimonial evidence and circumstantial. Scientifically, the term circumstantial is indefensible, for it does not correlate with testimonial. A more correct equivalent would be non-testimonial, but no one has yet invented an acceptable substitute for circumstantial. Wow, what a concept to consider now when it comes to evidence. So if it's not testimonial, it's circumstantial. And testimony has to be an assertion by a human being. So is all documentation circumstantial to some extent? Clear and convincing evidence, 17th century. Evidence indicating that the thing to be proved is highly probable or reasonably certain. This is a greater burden than the preponderance of evidence, the standard applied in most civil trials, but less than the evidence beyond a reasonable doubt, the norm for criminal trials. Yeah, we hear this a lot. So it's a clear and convincing as opposed to beyond a reasonable doubt. So it could be to some degree highly probable, not beyond a reasonable doubt. Yep, what a difference. Can be quite a contrast there. Then we have communicative evidence, the testimonial evidence, competent evidence, the admissible evidence, relevant evidence, conclusive evidence. 17th century, evidence so strong as to overbear any other evidence to the contrary, also termed conclusive proof. 2. Evidence that so preponderates as to oblige a fact finder to come to certain conclusions. So conclusive evidence. It obliges the fact finder to come to a conclusion. There's so much preponderance. So it gives before they can ponder it. All right, let's continue here. Concomitant evidence. 17th century, evidence that at the time of the act, the alleged doer of the act was present and actually did it. So the concomitant evidence is evidence that at the time of the act, the alleged doer of the act was present and actually did it. That's a lot of evidence. Then there's conflicting evidence. So 1803, evidence that comes from different sources and is often irreconcilable. And you have corroborating evidence, 17th century, evidence that differs from but strengthens or confirms what other evidence shows, especially that which needs support. Corroborating and corroborative evidence, got it. Credible evidence, 17th century, evidence as worthy of belief, trustworthy evidence. Oh gosh, I'm sure that one's misused. Critical evidence, 18th century. Evidence strong enough that its presence could tilt a juror's mind. Wow. That could tilt a juror's mind. Critical evidence. Under the Due Process Clause, an indigent criminal defendant is usually entitled to an expert opinion of the merits of critical evidence, also termed crucial evidence. So under the Due Process Clause, that's something to look into for further investigation. The Due Process Clause, I think that's something that should be revisited at a later time. So I'll leave that in the notes. Crucial evidence, critical evidence, cumulative evidence, 18th century, additional evidence that supports a fact established by the existing evidence, especially that which does not need further support. Demeanor evidence, 1909, the behavior and appearance of a witness on the witness stand to be considered by the fact finder on the issue of credibility. Witnesses here with demeanor evidence. Then there's demonstrative evidence, 17th century, physical evidence that one can see and inspect, can be demonstrated, right? An explanatory aid, such as a chart, map, and some computer simulations. Wow. And that, while of probative value, and usually offered to clarify testimony, does not play a direct role in the incident in question. This term sometimes overlaps with and is used as a synonym of real evidence. Also termed illustrative evidence. We saw this one, automatic evidence. Okay, we'll see all those synonyms there. There remains a source of proof distinct from either circumstantial or testimonial evidence. Wow, there remains a source of proof distinct from either circumstantial or testimonial. Let's see, what the tribunal sees or hears by its own senses, whether this should be termed evidence or not, is a question of words, open to difference of view, but is universally conceded to be an available source of proof. Wow. Bentham's term for it, real evidence, oh gosh, came into wide vogue, but it is ambiguous. The term autopic, I guess that's how you say it, autoptic, preference, etymology meaning showing, optic there, of course, showing to the tribunal's own vision. Autooptic, I guess is how it's somehow been contracted into autoptic. Okay, now we get the etymology. Thank you, blacks, for making us wait this long for that. Is preferable. And then again, that came from a student's textbook of law evidence from 1935. Surely nobody reads that one anymore but us. So salute to all you here tonight. Derivative evidence, 1961. Evidence that is discovered as a result of illegally obtained evidence and is therefore inadmissible because of the primary taint. Exclusionary rule, fruit of the poisonous tree doctrine. You got it? Direct evidence, 16th century. Evidence that is based on personal knowledge or observation, and that, if true, proves a fact without inference or presumption. Also termed positive evidence. opposed to the circumstantial and negative evidence. So, a little reflection shows that no disputed case will ordinarily be proved solely by circumstantial or solely by testimonial evidence. Wow. A little reflection shows that no disputed case will ordinarily be proved solely by those. Wow. Ordinarily, there is evidence of both kinds. The matter has been obscured by the use of the term direct evidence, a term sometimes used to mean testimonial evidence in general, but sometimes also limited to apply only to testimony directly asserting the fact in issue. The term direct evidence has no utility. Okay, so there, the ambiguity starting to blur the terms. This is interesting. It's based on personal knowledge or observation that, if true, proves a fact without inference or presumption. They call it direct evidence, but it's not. Wow. If true, positive evidence. So this does get kind of, you can see how it gets twisted here, and why you have to, when you have a full comprehension of the depth of these words here, again, from a textbook of law evidence, 1935, you can see where the twisting occurs and know how to straighten it back to the true intent. All right, documentary evidence, 18th century, evidence supplied by a writing or other document which must be authenticated before the evidence is admissible. Again, this is not, it has to be authenticated. Downright evidence. Evidence allude intrinsic evidence. All right, evidence in chief, 18th century. Evidence used by a party in making its case in chief. There's exclusive evidence, 18th century. The only facts that have or are allowed by law to have any probative force at all on a particular matter in issue. There is an important class of rules declaring certain facts to be exclusive evidence, none other being admissible. The execution of a document which requires attestation can be proved in no other way than by the testimony of an attesting witness. Wow, the execution can be proved no other way than by the testimony of an attesting witness, unless owing to the death or some other circumstance his testimony is unavailable. A written contract can generally be proved in no other way than by the production of the writing itself, whether its production is possible. The writing itself. That comes from John Salmon's jurisprudence. And there's exculpatory evidence. Evidence tending to establish a criminal's defendant's innocence. That's from 18th century. The prosecution has a duty to disclose exculpatory evidence in its possession or control when the evidence may be material to the outcome of a case. See Brady material, case law. Wow. Okay, expert evidence, 16th century. Evidence about a scientific, technical, professional, or other specialized issue given by a person qualified to testify because of a familiarity with the subject or special training in the field. Expert testimony. Then we have extrajudicial evidence, 18th century. Evidence that does not come directly under judicial cognizance, but nevertheless constitutes an intermediate link between judicial evidence and the fact requiring proof. It includes all facts that are known to the tribunal only by way of inference from some form of judicial evidence. So judicial, notice, wow. It's extrajudicial evidence. It doesn't come under judicial cognizance, but constitutes an intermediate link between judicial evidence and the fact requiring proof. Wow. Then there's extrinsic evidence. Evidence relating to a contract, but not appearing on the face of the contract. because it comes from other sources, such as statements between the parties of the circumstances surrounding the agreement. Intrinsic evidence is usually not admissible to contradict or add to the terms of an unambiguous document. So if the document is clear, unambiguous, then it's not admissible for any of these added terms. Extrinsic evidence, so it's relating to a contract but not appearing on the face. Wow. Let's see here. I missed something here. Also termed extraneous evidence. Parole evidence, spoken evidence, right? Evidence, okay. That is not legitimately before the court. Intrinsic evidence. Evidence that is calculated to impeach a witness's credibility. Wow, adduced by means other than cross-examination of the witness. This is a good one here. Evidence that is calculated to impeach a witness's credibility, adduced by means other than cross-examination. Wow, the means may include evidence and documents and recordings and the testimony of other witnesses. So under the federal rule of evidence, if the witness denies engaging in untruthful misconduct, the cross-examiner must take the witness answer, meaning the questioner may not introduce extrinsic evidence to contradict the witness's denial, though other witness testimony or the introduction of impeaching documents, or indeed any other evidence at the cross-examination, even if the questioner waits until it is his turn to put on evidence. Wow. So that's quite interesting there. Fabricated evidence, 18th century, false or deceitful evidence that is unlawfully created, usually after the relevant event in an attempt to achieve or avoid liability or conviction, also termed fabricated fact. False evidence, forensic evidence, 18th century, evidence used in court, especially evidence arrived at by scientific or technical means such as ballistic or medical evidence. Foundational evidence, 1946, evidence that determines the admissibility of other evidence. Habit evidence, 1921, evidence of one's regular response to a repeated specific situation. Habit evidence, regular response to a repeated specific situation. That's criminal. All right, hearsay evidence. We saw that. Illegally obtained evidence, 1924. Evidence obtained by violating a statute. Oh, illegally. Wow. Or a person's constitutional or other right. Wow, okay, so illegally obtained evidence. Especially the Fourth Amendment guarantee against unreasonable searches, the Fifth Amendment right to remain silent, or the Sixth Amendment right to counsel. Beautiful. Illegally obtained evidence from 1924. Saw illustrative evidence, immaterial evidence, 18th century, evidence lacking in probative value, to evidence offered to prove a matter that is not an issue. Then we have impeach evidence, 1861, evidence used to undermine a witness's credibility, similar to the other word we saw there. Impertinent evidence, irrelevant, incompetent evidence, 18th century, evidence that is for any reason inadmissible. That's incompetent evidence. And incriminating evidence, 1878, evidence tending to establish guilt or from which a fact trier can infer guilt. It's incriminating evidence. Then there's inculpatory evidence, 1849, evidence showing or tending to show one's involvement in a crime or wrong. Indirect evidence, indispensable evidence. So we could go on here for quite a while. Let me find out some good ones here. We have legal evidence, a 17th century. See admissible evidence. All admissible evidence, both oral and documentary, of such a character that it reasonably and substantially proves the point, rather than merely raising suspicion or conjecture. And then material evidence, 17th century, evidence having some logical connection with the facts of consequence, right? Or the issues, causes of action. Mathematical evidence, 18th century, loosely, evidence that establishes its conclusions with absolute certainty. Wow. 2. Evidence pertaining to mathematical or statistical matters or probabilities. A little bit different definition there. Medical evidence, moral evidence. Wow, 17th century, loosely. Evidence that depends on belief rather than complete and absolute proof. Generally, moral evidence is testimonial. And that is testimonial evidence, moral evidence. Wow. Another interesting one right there. Negative evidence. Well, there's going to be quite a bit here. Parole evidence is evidence of oral statements. Cases, criminal law, evidentiary rule. Let's see what else we have here. I think we're pretty prima facie evidence. 18th century evidence that will establish a fact or sustain a judgment unless contradictory evidence is produced. The legislative branch may create an evidential presumption or a rule of prima facie evidence. An example: a rule which does not shut out evidence but merely declares that certain conduct shall suffice as evidence until the opponent produces contrary evidence. Interesting. Primary is back to best evidence, privileged evidence. Okay, this is an important one. 1897, evidence that is exempt from production to an opposing party or tribunal with certain limited expectations, because it is covered by one or more statutory or common law protections, such as the attorney-client privilege. C. Privileged communication under communications. That's an important one there, privileged evidence. So then we have probable evidence, probative evidence, evidence that tends to prove or disprove a point in issue. Proffered evidence, evidence that is offered to the court to obtain a ruling on admissibility. Evidence whose admissibility depends on the existence or non-existence of a preliminary fact. There's prospect. Wow, so this could go on quite a while. Queen's evidence, testimony provided. Well, come on. We'll skip that one. Secret evidence, classified information, 1983. That may be used against the defendant in an immigration proceeding but withheld from the defendant, the defense lawyer, and the public on a national security. Okay. Signature evidence. Highly distinctive evidence of a person's prior bad acts. Wow. While ordinarily inadmissible, signature evidence will be admitted if it shows, for example, that two crimes were committed through the same planning, design, scheme, or modus operandi, and in such a way that the prior act and the current act are uniquely identifiable as those of the defendant. Pretty high bar there. Then we have slight evidence, a small quantity of evidence, especially the small amount of evidence sufficient to remove a presumption from a case. Okay, for a rational fact finder. Cool. All right, so let's get to some good ones here. Testimonial evidence, 1831, a person's testimony offered to prove the truth of the matter asserted, especially evidence elicited from a witness. An assertion is testimonial evidence, whether made out of court or in court, if it is offered with a view to persuading the tribunal of the matter to be asserted. The traditionary evidence derived from a deceased person's former statements. Unwritten evidence, evidence given orally. All right, and I saw some really good ones over here. Evidence of title, 17th century. The means by which the ownership of land is satisfactorily demonstrated within a given jurisdiction. See deed. There are four kinds of evidence of title: abstract and opinion, certificate of title, title insurance, and Torrens certificate. The certificate of title is used extensively in the eastern states and some southern states. In urban centers, in a great many sections of the country, title insurance occupies a dominant position in real estate transactions. In farm areas, the abstract and opinion method is common. To a great extent, the acceptability of a particular kind of evidence of title depends on the local custom. Great. Okay, so we've gone through evidence pretty well through Black's Law. Boy, I hope everyone's still with me here. We're almost to the 2-hour mark, but we're going to keep trudging through here because we have to get to the very last one of the night, which is proof. And here we are with proof. There it is. So proof comes from the 13th century. It's a noun, the establishment or refutation of an alleged fact by evidence. So it's the establishment or refutation of the fact by evidence. Remember, evidence is that procedure of making it evident or clear. The persuasive effect, the effect of evidence in the mind of a fact finder, which could be the jury. Evidence that determines the judgment of a court. So it's the type of evidence. The proof is the evidence that determines the judgment of a court. 3, an attested document that constitutes a legal evidence. We went through the legal evidence already, so beautiful. So now everything ties together very well with proof. And let's continue on. Affirmative proof, 18th century, evidence establishing the fact in dispute by preponderance of the evidence. So affirmative is by preponderance, not beyond reasonable doubt. Conditional proof, 1931, a fact that amounts to proof as long as there is no other fact amounting to disproof, also termed presumptive proof. We have double proof, 1955. It's from bankruptcies, proof of claims by 2 or more creditors against same debt. Corroborating government evidence by 2 witnesses required to sustain certain convictions. Full proof, civil law, proof by 2 witnesses or by public instrument. Evidence that satisfies the minds of the jury of the truth of the fact in dispute beyond a reasonable doubt. So that's the full proof, as opposed to the affirmative proof. That's a preponderance of the evidence. The affirmative proof affirms, but the full proof in civil law is a proof by 2 witnesses or by public instrument. It's the evidence that satisfies the minds of the jury of the truth of the fact in dispute beyond a reasonable doubt. No preponderance, beyond reasonable doubt. Literal proof, civil law, written evidence. Negative proof, 16th century. Proof that establishes a fact by showing that its opposite is not or cannot be true. Positive proof, 17th century. Direct or affirmative proof. Preliminary proof, insurance. The proof first offered in a loss occurring under a policy, usually sent into the underwriters with a notification of the claim, which we went over already. Proof beyond reasonable doubt, 1834. Proof that precludes every reasonable hypothesis except that which it tends to support. See reasonable doubt. Formerly, this standard required evidence to establish the truth of the fact to a reasonable and moral certainty, and proof to a moral certainty as distinguished from an absolute certainty. Moral certainty is no longer a synonym for proof beyond a reasonable doubt. Testimonial proof, civil law. Proof by the evidence of the witness, rather than proof by written instrument. So testimonial proof, as opposed to literal proof. Then we have proof, the burden of, proof of acknowledgement, proof of claim. So I think we're getting proof of loss, proof of will, and we have finished proof, which means that we have finished the live stream. Wow, salute to all of you that are still left here. This has been a tremendous live stream. It hasn't been as brief as I hoped, but it was under 2 hours, so I guess we could consider it somewhat of a brief course here. But we went over some very important words. Again, we went over allegation, we went over claims, we went over fact, we went over evidence, and we also went over proof in their entireties here, pretty much in Black's Law Dictionary, ninth edition. Salute to all of you that stayed here and stuck with me through this whole presentation. This is really, to me, it's an honor to be able to share this simultaneously as I explore these words even more deeply than any other time, because I guess having the communal effort like this encourages us all to take the extra time to do something which we may normally not have done. So, with that being said, again, I want to thank everyone for coming out. And please like, subscribe, and make sure you hit the notification bell to be alerted of any new episodes we put out here. Some more maxims of law, American jurisprudence, and other things that pertain to the way we can affect the, I guess, the purposes of the law and the intentions of it in our day-to-day lives to protect our life, liberty, property, and our pursuit of happiness. With that, I want to thank you all and bid you all peace out. I'll see you on the next one.